So, hi everybody, welcome back to Law Hero, and it is my favourite time of the year. It's FE1 review season, and we are kicking off this evening with contract law. And yeah, so thank you for everyone who reached out with their exam papers. I'm really grateful. I know that there's been some huge delays in people getting exam questions and whatnot, but hopefully if I share them up on here, up on YouTube. So the first thing we have to remember is just broadly, I mean, I've done tons of videos on FE1, so this is kind of different because the exams were online. But the one just gone, the one in November, that was the very first time the exams were online, which was amazing for me as someone who reviews scripts, because I no longer have to deal with people's handwriting, which I imagine for the online examiners, for the examiners themselves, was also amazing. But I guess then I suppose it's very clear who knows what. So yeah, it's a downside and an upside. I personally think typing things is way better. You can rejig your answer, but I have noticed from all the scripts I've reviewed from this November, some people are spending way too long on question one, just kind of as an anxious reaction to actually sitting an online exam and having someone staring at you through a webcam. It's not the most pleasant experience. So what I'd say is make sure you practice at home doing online kind of typing things before you go into the exam. Anyway, look, I've said all those things before in another video. So we're going to get into contract now. So we have Kalina Kelly, who is the internal examiner, and Fergus Ryan, who's the external. I would say they are pretty hard markers from what I've seen from people's stuff. The overarching kind of advice I would always give in contract law, it's a very structured exam. The first four questions are problem questions, the latter four are essay questions. If you're more of an essay style, academic style brain, obviously gear yourself towards the essays. If you're more of a practical person, you like solving problems, obviously the problem questions are better. And for the most part, like, people have the knowledge, they have the inherent knowledge of contract law because they've done it, we'll say, since university, but most people are not great at applying the law to the facts of the problem questions, and thereby application is pretty poor. So we're going to go into question one. I'm not going to read the whole question, I'm just going to give you the gist of it and how I would have answered it. So the first question, briefly, it involves an online forum where magazines are being sold, and you have two separate issues. The first issue is that there's a mistake in the purchase price offered. The girl puts up €50 for a sale of a comic and the buyer offers her 500, so that's a mistake. And then the second part of the question, there's a fake autograph on what she's selling, and then obviously then that's misrepresentation. And, you know, was she innocent in knowing, you know, did she know it was a fake? In this case she didn't. And this is another thing with the FE1, and I always say to my peeps, like, don't look past what is actually said in the exam question. So like, if the exam question states like, this girl didn't know it was a fake, don't you go and say, oh, it is unclear whether it is a fake or not, because you're given the truth. And like, as I was saying to one girl there last night, the exam question you get in the FE1 is its own ecosystem. When you come with your biases, you know, like your stuff from outside the question, or, you know, you're implying things that you know, or you're like, as Sherlock Holmes would say, you're trying to twist the facts to suit the conclusion, rather like the conclusion you've come to already. It's not like that. I want you to go into it with a very open mind. Only deal with the facts you're given. Do not impute or do not imply any knowledge into the question, and answer it on the face of what you're given. So yeah, the other thing as well is, like, I think her name's Rebecca. Yeah, it says advise. So the very first thing I would ask you to do is go down to the very end of the question before you do anything and see who your client is. And it says advise Rebecca, you advise Rebecca, and you don't worry too much about the other lads. Obviously you need to consider like what your defenses are as Rebecca, because they're going to obviously counterclaim that, oh, Rebecca misrepresented what she was selling, or Rebecca should have known I wasn't going to give her 500 quid for a magazine. All right, so that was the first one. I thought it was pretty straightforward. Again, if you spent ages writing about offer and acceptance and consideration, good luck, because that's not what this question was about. Okay, question 2 was a problem question. So basically this actress, is a bit like Downton Abbey, they spent $500,000 on the production beforehand. The actress gets on set, she only films a little bit, she doesn't fulfill her contract, she says it's a load of crap, and then she pulls out. So this is a bit like Tom Brady from the Brady Bunch, that case, Reed v Anglia Television, which deals with restitution. And the reason it's restitution is because obviously their contract is with her, okay? So like, I contract you to act for 3 months. It's not really my problem if you spent $500,000 on the production beforehand, but then is it? Because that case said that money was spent in reasonable expectation that she would, or that he would act, and basically they needed him because he was the star of the show. And if you have no Tom Reed, then you have no show. So then if I spent $500,000 beforehand, that should be kind of factored into it, but it's not damages because you haven't suffered the actual damage yet, you just haven't made any profits. So yeah, it's restitutionary. It's a bit like tort. You want to put them back in the situation they were in before they spent the money. So that's what that question was kind of getting at. And then of course, like, because she has alluded to the fact that she's not going to come back on set, that is anticipatory repudiatory breach, because they've anticipated that she's repudiating the contract, which is a common law breach, and which gives them the right to terminate. That's the most important thing. Can they terminate this contract? Because if they allow this wrong to continue, that's called, you know, like they're not mitigating their damages, or their potential damage, or their potential loss, which is, you know, the onus is on the plaintiff to always mitigate their loss. So if they keep paying this actress and she's like slandering them on social media, yeah, they're not mitigating their loss. They're acquiescing to her misbehavior, essentially. Okay, so the third question was a problem question around parking and exclusion clauses. Okay, so when it comes to, we'll say, like private operators, for example, car parks, when they have, you know, terms and conditions apply, see our website. You know, when you hear that, we'll say, for example, around financial services ads, like no one really goes to the website and looks at the terms and conditions, but the fact that they've said it in the ad, it's kind of, you know, making the consumer aware where to find the terms and conditions. And actually, if they've done that, that kind of satisfies their obligation. They have to make the consumer aware. Now, like, it does say in this question, he saw the sign saying terms and conditions apply, so, but he didn't bother checking it. So that is kind of his issue, because like the parking company can't, well, they could, I suppose, but they're not really going to go around and read the terms and conditions to everyone, or like print it off and put it on everyone's dash. Like, that's not very feasible. So the website thing, or, you know, having the terms, like I know in McDonald's, for example, they have, and I used to frequent McDonald's a lot, so I used to, while I was waiting for my whatever, like chicken burger, I would read the terms and conditions, which were right beside the counter. So if you're waiting for your burger, you could just read them. Or if you're just sad like me and don't go on social media and just read things on walls. But the fact of the matter is, like, they're there for you to see, and they're also on the website. So they have brought it to the attention of the customer. So then the fact is it incorporated into the contract? More than likely, yes, because we're told he has seen it. Then the next issue then is the exclusion clauses, because as we know, you can't exclude, you know, certain negligence and liability when you're in a consumer contract, and we know that from section 55(4) of the 1893 Act, and you'll see all that in the chapter in consumer law. But what that basically means is, like, you can contract out of those whatsoever when it comes to consumers. If it's B2B, you can, if it's fair and reasonable, but that's a lot of the time up to negotiation. Question 4 then is, was a working to contract and a part payment force majeure here, because, like, it's a pandemic, and it's a pandemic would normally come under a force. So I would actually throw that in there because it basically puts a stay on what's happening. Whereas frustration is like, you know, the incarnation cases where, you know, they were relying on another event to happen. So I actually don't think this is frustration. I think this is more force majeure. But the question here is, you know, can the builder escape liability, or do they have to pay a higher sum to cover the cost of the workers? Because obviously health and safety is increasing after COVID, and they have more of an expense. So you would say arguably that expense should, you know, the expense that the contractor has to bear should be offset by the employer, by the person having them on site, because that's fair. So question 5 asked, what ways can an offer be terminated, and is there any way for an offeree to ensure that an offer will remain open? Well, I suppose like through a counter offer. You could try and extend the period of time to ensure that, or you could put in exclusivity to ensure that the offeror doesn't offer to anybody else. And I don't really do it in the Law Hero notes, is so like an option contract leaves the offer open. Basically it gives you time. So for example, land, for example, so we'll say like if you're selling land, like you give someone the option to buy it, but it's like there's no condition on when. Now there might be a condition on when, but you basically get more time than a regular offer, and that is one way. But I wouldn't recommend doing that essay because, you know, it's a very niche area of contract law and I don't cover it in my ebook. Question 6 is, with reference to relevant authority, discuss the rule in Pinnell's case and whether promissory estoppel can provide a remedy to the party, a debtor who has relied on the promise of the creditor to accept a lesser sum in satisfaction of a larger debt. Question 7 is an essay question. What does a declaration of frustration have on a contract? So yeah, I think definitely that question earlier must have been force majeure, because force majeure and working to contract and par payment, because this seems to be an essay on frustration. And then question 8 was answer A or B. Explain the approach of the Irish courts in relation to someone standing as a guarantor for a loan from a bank that claims they act under undue influence, or the approach to Irish courts of penalty clauses in contracts. I mean, that was fine. So yeah, overall it was a fine paper, I thought. Nothing really, like the options contract is probably a new one, but I guess they're trying to, you know, broaden the scope of what they're asking a little bit. Yeah, I hope you enjoyed this video, and make sure you get your FE1 notes on lawhero.eu. Continue to subscribe for more, because I'll be doing all 8 FE1s on YouTube at the moment. See you in the next one.